Removal of Chief Justice, Her Ladyship Gertrude Tokonu, has been very, very topical. So we'll talk about it in some great detail now. And Crosby, we started the conversation off this morning with what the headlines had to say. This case or this particular issue has traveled a bit of a course, but by way of information and by way of education, let's get into Article 146 of the 1992 Constitution of Ghana. Crosby, please do us the honors.
Well, let's talk about Article 146, as you mentioned, the removal of justices of Superior Court and chairmen of regional tribunals. That is what the focus of Article 146 of the Constitution is about. Now, for the first one, a justice of the Superior Court or a chairman of the regional tribunal shall not be removed from office except for, one, stated misbehavior or incompetence, or on the ground of inability to perform the functions of his office arising from infirmity of body or mind. So that is the only way where you can remove a chairman of a regional tribunal or a justice of the Superior Court. And we know who the justices of the Superior Courts are. For instance, the Supreme Court justices are justices of the Superior Courts. High Court judges are also justices of the Superior Courts. Let's move on. Now, a justice of the Superior Court of Judicature or a chairman of the regional tribunal may only be removed in accordance with the procedure specified in this article. So it cannot be anything else but the procedures laid out in the Constitution. I'm talking about Article 146 of the Constitution. If the President receives a petition for the removal of a justice of a Superior Court other than the Chief Justice, so this is in two parts. The first part is anybody else apart from the Chief Justice, anybody else who is a justice of the Superior Court or a chairman of a regional tribunal other than the Chief Justice, this is what will happen. So he shall refer the petition to the Chief Justice, because it's not the Chief Justice who is in question here, who shall determine whether there is a prima facie case. So in this case, the President receives it and gives it to the Chief Justice. Then the Chief Justice will determine whether there's a prima facie case in the petition that has been brought before him or her as the President. Let's move on. Let's talk about the next one. Now, where the Chief Justice decides that there is a prima facie case, the Chief Justice shall set up a committee consisting of 3 justices of the Superior Courts or chairmen of the regional tribunals, or both, appointed by the Judicial Council, and 2 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers, and who shall be appointed by the Chief Justice on the advice of the Council of State. Remember that this, we're talking about anybody else but the Chief Justice. So because the Chief Justice in this case is not involved, he or she is making concrete decisions in this aspect. Now, the committee appointed under Clause 4, what we just spoke about, they shall investigate the complaint and shall make its recommendations to the Chief Justice, who shall forward it to the President. Remember that the President received the petition and they gave it to the Chief Justice, and the Chief Justice continued with the process. After the committee, the work of the committee will be brought back to the Chief Justice, and then it will be taken back to the President. Where the petition is for the removal of the Chief Justice. Because
this is where it gets interesting, Crosby. Exactly. This morning you set out that premise that because the individual in question is the Chief Justice, there are some elements that should pique our interest.
Yes.
All right.
So this one is in relation to what is happening in our Omofia right now.
Right.
Where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee. And that committee consists of 2 justices of the Supreme Court. So any of the justices at the Supreme Court can be taken.
Right.
One of whom shall be appointed chairman by the President. After these 2 justices of the Supreme Court, then there are 3 other persons who are not members of the Council of State. These 3 other persons should also not be members of Parliament. They should also not be lawyers. Mind you that this is in relation to the removal of the Chief Justice. When the President receives the petition, the President acts in consultation with the Council of State to appoint a committee.
Okay.
And we've spoken about the membership of the committee. 2 Supreme Court justices, one of whom will be appointed the chairman by the President, and then 3 other people who are not MPs, who are not Council of State members, who are not lawyers. Let's move on. Now, this committee that was spoken about they shall inquire into the petition and recommend to the president whether the Chief Justice ought to be removed from office. You see the difference here?
Right.
When we're talking about anybody else but the Chief Justice, when we're talking about justices of the superior courts and chairman of the regional tribunal, when the petition is received by the president and the president gives it to the Chief Justice goes to find out if there's a prima facie case by the petitioners against, the people they're accusing. So in this case, the chairman of the regional superior court. In this case, you're not seeing any mention of a prima facie case. It's related to the Chief Justice.
Right.
Clause 7 says that the committee appointed under Clause 6 of this article, they shall inquire into the petition. We've spoken about the membership of the committee, the 5 people, and recommend to the president whether the Chief Justice ought to be removed from office. Let's move on. Now, all proceedings under this article shall be held in camera, and the justice or chairman against whom the petition is made is entitled to be heard in his defense by himself. So in this case, we're talking about the Chief Justice herself, or by a lawyer or other expert of his or her choice.
All right. This is very instrumental when we come to unpacking some of the recent happenings.
Yes. So the president shall, in each case, act in accordance with recommendations of the committee. The president will set up the 5-member committee in consultation with the Council of State. They will look into the petition, whether or not the Chief Justice should be removed. The Chief Justice is entitled to be heard. Recommendations are made to the president after everything, and that the president is bound by the Constitution to act in accordance with the recommendations of the committee. So if the 5-member committee that we already spoke about, if the committee says that remove the Chief Justice, the president has nothing more to do than to remove the Chief Justice.
Right.
If we're looking at Clause 10, where a petition has been referred to a committee under this article, the president may, and this is A, in the case of the Chief Justice acting in accordance with the advice of the Council of State, again, the Council of State is involved, by a warrant signed by him, suspend the Chief Justice. This is not mandatory. This is a discretionary power of the president, but he has to do this in accordance with the Council of State.
Right.
By a warrant, suspend the Chief Justice if he wants, because maybe the thinking is that if the Chief Justice is still at post, he or she may interfere with the investigations, it may compromise, the way the case is being held and all of that. 10B. In the case of any other justice of a superior court or of a chairman of a regional tribunal acting in accordance with the advice of the Judicial Council, suspend that justice or that chairman of a regional tribunal. So the president is still able to suspend, the chairman of the regional tribunal or the justice of the superior court whom the petition has been brought against. So this is what the Constitution is talking about. Now, if we're looking at 11, the president may at any time revoke a suspension under this article. So if the president wishes, and then if he gets the warrant to act in consultation with the Council of State, suspend the Chief Justice after a while, at any time, maybe after a day, after 2 days, the president can decide that, well, I decided to suspend you. Now I'm not suspending you again. Come and still take up your duties as the Chief Justice.
Certainly.
Yes.
All right. We'll also take a look at some previous cases and some precedents that may have been said. You've got A.A. Benin in Derry versus Tiger IPI and AG. Now, according to this case, there are no hard and fast rules in place, but the rules of natural justice and the right to fair hearing will just dictate that the Chief Justice should at least seek a response to the petition from the named respondents before making a prima facie determination. All right. So a prima facie determination, and by whom? There's also Ace Ankoma, senior partner at Bensi, Enchil, Lecha, and Ankoma. Article 146 requires that before the CJ sets up a committee to consider a petition to remove a judge, the CJ must establish that there is a prima facie case. However, the article is silent on whether this prima facie determination also applies if the CJ is the one against whom the petition has been filed, and if so, by whom. So Crosby,
that is the opening. That is the, I don't know whether it's a gray area, it's a blank space, it's a blurred line in the Constitution that these people who are taking the case to court are basing on. Because if you read the Chief Justice's request for the petition, although the Constitution says that the Chief Justice is entitled to be heard as part of the process, there is no determination or no mention of a prima facie case when it comes to the CJ, him or herself. It is there for the other justices or the regional tribunal, but the Chief Justice, is not mentioned in. Let's look at, in this case, the CJ, the Supreme Court resolved this in Frank J. Chum versus the Attorney General and One Bright Equity. This was in 2006. The Supreme Court held that the Constitution requires a prior determination of a prima facie case against the Chief Justice before the President can establish a committee to consider a petition for removal. This omission in Article 1466 leads to a manifest absurdity that the court should avert. So this is a ruling of the Supreme Court. If you like, because there was an opening there, somebody took this to court, and the Supreme Court took advantage to solve it. This is what it said. The Supreme Court said that the Constitution requires a prior determination of a prima facie case against the Chief Justice before the President can establish a committee to consider a petition for removal. So the Supreme Court said, although it was not mentioned, going forward, we should do this. There should be a prima facie case against the Chief Justice before the committee is established.
Okay.
So right now that the President has it and is in consultation with the Council of State, this should happen according to 2006 Frank J. Chum versus the Attorney General and Bright Equity. Now, the Supreme Court also held that before appointing the committee to investigate a petition to remove the Chief Justice, the President and Council of State should determine if the petition establishes a prima facie case, potentially seeking advice from an independent lawyer. So they're trying to bring in the element of a prima facie case here as well, because it was not mentioned. They're trying to, clear this, what the absurdity, if you like, or the blurriness, because that was not mentioned in Article 146 of the Constitution.
Right.
There's a question to ask in all of this, Helen. How is the prima facie determination made? And is the respondent required to be heard?
That is in the determining of the prima facie case.
Exactly.
All right.
So you have read the petition. The person has not been invited. The person the petition is against has not been invited yet. But the person is entitled to be heard. How should it happen? Based on the rulings of the Supreme Court, the last one was in 2006. Based on this question, the Supreme Court held this, that the prima facie determination required upon receiving a petition, it means that examining available evidence to determine if the petition raises serious issues warranting further investigation. Now, this requires seeking a response from the named respondent before making the prima facie determination, as this involves examining available evidence in a quasi-judicial decision-making process. Let's look at what the Supreme Court in Frank J. Chum versus the Attorney General said. I am inclined to grant the plaintiff a declaration that the consultation by the President with the Council of State in respect of the appointment of the committee to inquire into a petition for the removal of the Chief Justice shall determine whether the said petition discloses a prima facie case before the committee is appointed. This was a position of the Supreme Court in Frank J. Chum versus the Attorney General, Helen.
All right, so now we could take a look at the suit challenging the removal of the CJ. Now, this was brought forth by Old Tafo MP Vincent Eko Asefo. Now, he's seeking a declaration that upon a true and proper interpretation of Articles 146 and 296 of the Constitution, the President is mandated to notify the CJ about a petition for the removal and solicit comments. Now, Crosby, when we put this side by side with the Constitution, is this particular request in line? He's saying a declaration that upon a true and proper interpretation of Articles 146 and 296 of the Constitution, the President is mandated to notify the CJ about a petition for the removal and solicit comments. Now, a declaration that failure by the President to notify the CJ and obtain comments violates Article 146 and protection of the security of tenure of the CJ. He's also requesting a declaration that failure by the President to notify the CJ amounts to an unjustified interference with the independence of the judiciary.
Helen, if you're looking at the input of all of what is happening, the suits, and this by Vincent Asefo and the position of Gertrude Tokonu, the input is that the right to make her know about the petition is that this is more like what people are calling a quasi-criminal action. So it is deemed as though the CJ has committed an offense. If you have committed an offense, you have been brought to somebody to look into it, it is only quote-unquote proper that I ask you to come and explain yourself. They say you have committed the offense. Is it true? What evidence do you have to say that you did not commit the offense? The people who are alleging, what evidence do they have that you committed the offense? So essentially, that is what these suits are saying, that the CJ should be notified or should be involved in all of these things, because if she is not involved, then it looks as though...
But her involvement does come at a point, because finally what also the suit by the Honorable Asefo is seeking is finally a declaration that the failure by the President to notify the Chief Justice constitutes a violation of the fundamental right to a fair hearing contained in Articles 23 and 296 and renders the consultation processes for the removal of the CJ initiated by the President null, void, and of no effect. But Crosby, you gave us some education at the beginning. The CJ does have an opportunity after that panel is constituted to also...
So in fact, the Constitution puts it, the CJ is entitled to be heard. But the question is, when? You know, is it after the determination of the prima facie case that was not mentioned in the Constitution, or before or after that? So we don't know when the CJ is entitled to be heard. So in all fairness, just like Asefo is saying that, the right to fair hearing, let me see the content of what is against me, so that I can adequately prepare. To the lay mind or to the lay understanding, this is what it means.
All right. Very shortly, we can also take a look at the petition from the Chief Justice. As you may know, she is requesting copies of the petitions. Now, how many? 3?
Yes, three petitions from 3 different people. From
3 different people seeking her removal. All right, so that is captured here. And it is as follows. Now, request to be given copies of petitions submitted against Justice Gertrude Araba Isaba Saki Tokonu, Chief Justice of the Republic of Ghana, before conclusions of consultations between His Excellency the President and the Council of State under Article 1466. It says, please find attached a copy of letter addressed to the following persons: A, His Excellency the President of the Republic of Ghana, the Honorable Do Ajaho, Chairman of Council of State and former Speaker of Parliament. C, the Honorable Justice Sophia Akufu, Member of Council of State and former Chief Justice of the Republic of Ghana. Now, in the said letter, she says, I humbly request for copies of the petition to remove me from office as Chief Justice. Please accept my compliments. And this is signed Justice Gertrude Saki Tokonu, Chief Justice. And that's that petition there from the Chief Justice. And of course, it goes on to... okay, that's it there. That's the end of it. Signed by the Chief Justice. We've had a look, though, at the processes according to Article 146. We've also taken you through some previous cases and what they've had to say about this. You see also from the suits challenging the removal of the CJ from Honorable Vincent Assefuah that the issues of natural justice come up.
So the last but one paragraph of the Chief Justice's petition to the President wanting to see what is against says this: I am by this letter humbly and respectfully asking His Excellency the President and eminent members of the Council of State to forward, and that's in is written in bold, to forward the petitions against me to me. Forward the petitions against me to me, and allow me at least 7 days after receipt of same to provide my response to you, which response can then form part of the material that you conduct the consultations anticipated under Article 1466 before possible setting up of the Committee of Inquiry under Article 1467. So she wants to receive the petition before and then respond before this committee that should be set up. This 5-member committee that should be set up is set up.
What effect, though, does that have on the status quo? If we look at what the Constitution has to say, there's certainly a lay-down procedure, and that does not involve forwarding the petitions as requested to the CJ, as she's saying. So that would be a deviation, if you will, from the strict rules of the Constitution.
Well, there's no mention that the CJ should be given the petition, but is there mention that the CJ should not be given the petition? Okay,
so that if you are towing the line of Honorable Vincent Assefuah, you would be thinking along the lines of natural justice, and whether or not the current process for handling petitions against the Chief Justice align with the principles of natural justice. So let's take a look, though, back at what Honorable Assefuah is asking. He's asking that there be a declaration that upon a true and proper interpretation of Articles 146, and it would be pertinent for us to also read 296. 296, I believe, talks about natural justice.
Yes.
Now, of the Constitution, the President is mandated to notify the CJ. Now, the language there is instrumental. Mandated. Where does he stand on? What provision is he standing on to say that the President is mandated? Where does he pick that from? If he says he's mandated to notify the CJ, we see that the Constitution does not say that the President is mandated to do so. But he says upon a true and proper interpretation of Articles 146 and 296, that should be the case. Well, is it the case that because of the issues of natural justice, that should be the way in which this should be interpreted? But let's jump on to the phone lines right about now. We've got Mr. Alexander Kojo Aban, former NP private legal practitioner. Good morning to you, sir.
Good morning.
I hope you're doing well.
I'm good. I hope you're also doing well.
Yes, I'm doing fantastic. Thank you so much for joining us on the program. We are discussing the latest as far as the removal of the Chief Justice is concerned. But from where you sit, what are your thoughts on the argument that the Chief Justice should receive copies of the petitions before a prima facie determination is made?
Thank you very much. There are people who are making the case that the provisions in the Constitution, by this I mean Article 146, does not say that the President should make the content of the petition known to the subject of the petition, that is the Chief Justice. I'd like to differ from those people, because the truth of the matter is that it's a cardinal principle of law, but one of the elementary principles of law, that you cannot judge anybody without a person. We put it in, we render it in Latin as audi auterum partem. That is, you must hear the other side.
Right.
No matter what it is, no matter how flimsy the complaint may be, once it's about somebody, it is natural and accords well with what we call natural justice, that the person is furnished with what people are saying about her. And so I think it's a right call that even if before it gets to her, the committee that may be set up, they would look at it and say that, oh, this is a very foolish matter, so let us throw it away. It should not be said that because they did not find prima facie matter, she should not know what people think about her.
Right.
Because even knowing what has been stated, no matter how weak probative quality that it may have, it is so necessary for her to know that, oh, this is what people think about me. This is how they see me. Okay, let me now readjust myself, or let me take into consideration these things that they have mentioned and conduct myself appropriately, or change my ways, or probably give explanations sort of to why certain things were done by me. So it is necessary for her to know the content of what people have stated about her.
Okay. So let's practicalize this then. Now, because the Constitution is silent on when a petitioned CJ should be informed, in your legal opinion, what would be the fair approach to balancing due process with protecting petitioners? You say that once a petition has been forwarded, at that point the CJ should be given these petitions, should be privy to these petitions. Is it at that point that you argue the CJ should be roped into the procedure?
I think that anybody who has thought about it to say that, yes, I have a case to make against the Chief Justice, should also be bold enough to say that, yes, I'm ready to face the person I'm accusing. Because it's a cardinal rule of law that let your accuser, the accused person must be given the opportunity to face or meet the accuser. So once somebody has had the boldness to accuse the Chief Justice, he should stand ready also to meet face to face with the person.
Well, critics argue, though, that premature disclosure of petitions could endanger complainants, especially if allegations involve abuse of power. How then do we ensure fairness and protection in such cases? I know you say that they should be bold enough to come out, but these are not themes that we can ignore.
Why do we think that we should protect the identity of the people who are making allegations about somebody, but we should not protect the integrity and the name and the image of the person against whom allegations have been made?
How do we balance those two elements?
Good. So in balancing it, you let the accused person, in this case the Chief Justice, know who her accusers are. Right? After all, we go to court, we stand in the box to testify against criminals and all that. Those ones, do we not always have the fear that there could be reprisal action from the accused persons? Why is it that in those occasions we allow the witnesses to meet the accused person in the courtroom, and after that there is no protection for them? But why is it that in the case of the Chief Justice, we even think that she would rather do reprisal action against people who have petitioned against
Is that a far-fetched assertion?
Even criminals who go, armed robbers who go with arms in their hands, we meet them in courts We testify against them. They see our identity, and no action is taken to protect the witnesses. But in the case of a very harmless person, whom we have not heard any criminal actions from her, we think that in her case, she rather has what it is to do reprisal actions against the accused person, so the accusers. So we should protect the accusers and not her name. I think that would be an imbalance.
Right. Now let's talk about Article 146. Now, some have called for constitutional reforms to clarify Article 146 procedures. Now, what specific reforms, from where you sit, would you propose to improve transparency so that we don't come back to this point time after time?
Let us start from probably the mindset of the framers of the Constitution. They may not have thought ever that the process of appointing members of the Council of State or electing members of the Council of State will be so politicized that in the final analysis, the crop of persons who form that august body virtually become politicians. Now, let us look at the current composition of the Council of State members. Virtually, the areas that we had elections, almost all those who won have some connection with the ruling government. We cannot run away from that. You can check, you can do a cross-check of that. That's point number one. Point number two, the rest who are also appointed by the president, obviously, will be persons who are aligned with his thinking. Right? So it appears to me now that removing a Chief Justice is probably much easier than removing other members of the Superior Court of Judicature. Because the political biases may even be more pronounced in that level. Because now, the persons who are going to be drawn, or who are going to look at it, are virtually persons who are politically aligned. And so if they decide that, look, this is our party, this is our president, who is on record to have stated that it would take a new Chief Justice to be able to bring some kind of sanity into the judiciary. At the time he made this statement, Getutokunu was the Chief Justice. So, implicit in that statement is that he does not want the current Chief Justice to be there. And so, if it is an agenda, it can easily be rolled out and executed. So, this is our president. We are aligned with his party. This is his vision. Let's help him to execute that vision. And so you can have some rented petitioners who will bring these petitions, and if they are going to be literalists, to say that, oh, the law does not say we should let the Chief Justice know the content, you will get a funny committee and very pliable persons who will just say that, oh, there's prima facie case.
Very interesting choice of words. You say rented petitioners, a funny committee. So you say that definitely these changes have to be made. Stay with me, please, Mr. Abba. Let me introduce also into the conversation Mr. Inusa Fuseni, former MP, Tamale Central, also private legal practitioner. Good morning.
Good morning. How are you?
I'm doing great. How are you doing?
Well, you can't complain.
All right. Thank you so much for joining us on the program. And I'll get straight into my questions. Given your experience in law and governance, do you believe that withholding petitions from the CJ at the early stage is a necessary safeguard, or is it a violation of natural justice?
is definitely a necessary safeguard for the sanctity and dignity of the office of the Chief Justice. If the office of the Chief Justice can be inundated with frivolous petitions, which will require a response anytime such a petition is filed, then we will be cheapening or reducing the aura surrounding the office of the Chief Justice. That is why, even though in Article 146 of the Constitution, there is no requirement of the establishment of a prima facie case, but all juries, including the Constitution Review Committee, have come to the conclusion that it is important and necessary to read into Article 1466 the requirement of the establishment of a prima facie case when a petition seeking the removal of a Chief Justice is involved. Why? In my view, it is intended to protect the dignity and sanctity of the office of the Chief Justice.
So Mr. Fusendi, from what I gather then, do you agree that Article 146 structures its process in a way that prioritizes preliminary assessment before notifying the subject? And if you agree, would you say that then that still doesn't interfere with the rules of natural justice?
No, at that point, it doesn't interfere with the rules of natural justice. And indeed, the rules of natural justice are common law rules. And the courts have consistently said, in all the cases, Bilson and Apollo, in Ghana, the Ghana Bar Association GBA against the Attorney General, and the Frank Ajechum against the Attorney General and Brad Cote, the juries, the courts have always said, the Supreme Court has always said that the requirements of the statutory requirements of for the performance of a duty are not displaced by common law rules. They are not displaced. And so the establishment of a prima facie case, and if you want by parity of analogy, is similar to what we encounter in criminal prosecutions when lawyers for defendants file a submission of no case.
Right.
At that point, you don't respond. You don't respond to the content of the petition. Prima facie is simply when you file a submission of no case, you're simply saying that the case of the defender, the case of the complainant or the prosecution does not raise any issue that requires my response, that requires me to defend the case. He's not raised any prima facie case of guilt. Or put otherwise, if the respondent or the defendant or the accused person does not open his or her defense, is the evidence submitted enough to secure a conviction? The same thing with removal of that's the general principles behind prima facie. And prima facie is Latin, which simply means on the face of it, on the face of the petition, assessing the petition, does it raise reasonable course of action? Does it require you to call on the Chief Justice to respond to them? That is why, in my view, I think the Chief Justice is jittery. And maybe I just listened to the person you spoke to before.
Yes, Mr. Alexander Aban, former MP, private legal practitioner.
My good friend Aban, Alexander Aban.
That's right.
Maybe it is the premonition informing the composition of the Council of State that is making the Chief Justice jittery.
You use the word jittery. I mean, so far she's only requested copies of the petition. How do you equate that to jitters?
Well, what about if the Council of State comes to the conclusion that the petitions are not weighty enough to require the Chief Justice to open to be investigated?
Right.
And are you suggesting that the Council of State cannot come to that conclusion? Is that the feeling that I get? If that is the feeling, it is what is pushing that narrative of Justice Aban is what is pushing the Chief Justice to try to use practices that she developed under Article 1463 when a petition for the removal of a Superior Court of Judicature is referred to her, to try to supplant the requirements of determining a prima facie case in Article 1466.
Mr. Fuseni, thank you for these thoughts. Please hold the line for me. I do have some more questions for you, but I do want to also pick the thoughts of Mr. Aban on this particular point. Now, Mr. Aban, what do you say then about this issue of Article 146 simply structuring the process in a way that prioritizes preliminary assessment? It's a preliminary assessment that determines whether or not the issue will go forward. What is the real issue here if you balance it in this direction?
Yeah, thank you very much. My friend, Mr. Fuseni, have a good morning. But the point here is this. He used the criminal procedure of submission of no case as an example. But therein lies the fallacy of his argument. Now, in the criminal justice system, the accused person from day one knows the charges against him. And he goes through the whole process until the prosecution has closed its case. It is only then that, after reviewing the evidence that has come, the accused person's lawyer will then apply it to the law and make an application and a case to the court that, looking at all the evidence that has been stood against my client, there is no need for the court to call on him to give an answer because there is no prima facie case. If the court opposes, the matter ends. But it doesn't take away the fact that from day one,
All right, Mr. Aban, we appear to have some challenges on the telephone lines. We'll try and get back to you. We're having some issues on the telephone lines. We'll try and get back to you and get your thoughts on this. But we still have former MP Tamale Central, Mr. Inusa Fuseni, also private legal practitioner, on the phone lines. Mr. Fuseni, I think you heard the import of what Mr. Aban was saying.
Exactly. So I baited Aban, and he swallowed the bait, hook, line, and sinker. In criminal prosecution, that is the procedure. That is the procedure. In removal of Chief Justice or Justices of the Supreme Court, that is not the procedure. That is not the procedure. So you see, that is why it is important to bait people who think that way. Where a procedure is provided for the enforcement of a right, you need to follow that procedure. That is what the rule of law, the question of the rule of law is all about. And I'm saying that in the case of the Chief Justice or the removal of the Justices of the Superior Court of Judicature, that is not the procedure. Such a procedure has not been provided.
All right, Mr. Aban joins us back onto the phone lines. Yes. We lost you briefly. You're back on the line. Let's hear you, please.
Yes. I was making a point, and I'll respond to what he has just said. But I was making a point that if we think that we want to draw a balance between protection of the identity of those who made the complaint as against the image and the name of the Chief Justice, then we could submit to her the nature of the complaint without disclosing those who made the complaint. And we are doing proper balancing so that she knows what the complaint is about, regardless of who is the author of the complaint. Now, I believe my senior is relying on the case of NTAC versus Boyfield, where Justice Aqua stated clearly that where there is a particular rule of procedure to be followed in prosecuting any kind of matter, it is that procedure which must be followed. What we must understand is that the Constitution and its interpretation is different from rules of procedure. Right? So not everything can be put in the Constitution. And that is why beyond the letter of the Constitution, we are guided by what we call jurisprudence. What has been our jurisprudence in dealing with any text? It's a cardinal rule of law. Listen to the other party. So if somebody has made an allegation against a Chief Justice, it could still be brought to her attention without necessarily showing who the authors are or the petitioners are. Then she could still be made to wait as the committee evaluates the merit of the petition. If they go ahead to say that, look, we have not seen any weighty matter, and so it is dismissed, the Chief Justice will not be called upon to give any answer. But at least she would have known the kind of allegations which are leveled against her anyway. Would that not be a fair way of going about it? And in any case, if you say that, this is the procedure, and that procedure is to protect the sanctity and dignity of the office of the Chief Justice, I don't agree. That office is always, if I may put it, sacrosanct.
Right.
We are talking about a person who is occupying it, because after all, if they make the allegations against that person, it is that person who will be removed. But the dignity of the office will still be intact. That's what you must understand.
All right, Mr. Aban, your thoughts clearly put forth on this particular issue, but stick with us. I do have some more questions for you. I'll come back to Mr. Fuseni and we can make some progress on this matter. Now, Mr. Fuseni, do you believe Ghana's constitutional provisions on judicial accountability are strong enough, or do you think that it leaves room for manipulation?
I think that...
Is that question to me?
This is for Mr. Fuseni.
I think that basically I will answer it in this way. The independence of the judiciary is very important in any democratic setting, because the judiciary is the bastion for the protection of rights of the citizens of a country, and also holding a government that is overzealous in the way it treats its citizens accountable. It is only the judiciary that can do that. Now, so the provisions in our constitution keenly aware, and I'm talking from the 1969 Constituent Assembly's report, keenly aware of how a pervasive executive can be, have put in institutional structures to safeguard the independence of the judiciary. And we have not departed. You know that experience in the First Republic, when Dr. Kwame Nkrumah removed a Chief Justice, that informed how we couched the provisions ensuring that the judiciary has some independence. And this is why, even in the 1969 Constitution, the drafters of the Constitution settled on this procedure. And Ms. Aban, the procedure is provided in the Constitution. So NHTC versus Buefio still applies in this constitutional matter. The procedure provided in the Constitution ought to be followed. So if a president receives a petition for the removal of a justice of the Superior Court of Judicature or the Chief Justice, the procedure provided in the Constitution has to be followed. That is the essence of NHTC and Buefio. Now, so we have said in 1969 that we are going to depart from the British way of removing a justice of the Superior Court, which is simply an address to the House of Parliament. Or the American way of removing a justice of the Superior Court of Judicature, which is by impeachment, to a position where the president receives a petition, or the prime minister then receives a petition, forwards the petition to the Council of State, and a judicial tribunal, that was how it was called in 1969, a judicial tribunal is established, which composition is not too different from the judicial tribunal, from the committee to be established under Article 1466 to determine whether a Chief Justice be removed. That was how we insulated the office of the judiciary. And so the President, on the basis of the principle of separation of powers, cannot so motu remove the head of a branch of one of the arms of government. You cannot remove the Speaker, you cannot remove the Chief Justice, unless the procedure for the removal of a Chief Justice is followed.
Right. I suspect Ms. Aban might have a contrary view, but I'll pose the same question to him. Mr. Aban, are you still with us on the line?
I'm here.
All right. So I also want to ask whether or not you believe Ghana's constitutional provisions on judicial accountability are strong enough, or are you of the view that it leaves some room for manipulation?
If you read the Constitution, it says that even the financial administration and management of the judiciary will not be questioned by the executive, sort of. Of course, there will be a budget which would be approved by Parliament, and there's always, if I say, Attorney General who is in close collaboration with the judiciary, all right. But there is some kind of independence, because if we take the independence of the judiciary, of our democracy is dead. And so that is why it is difficult for a president to remove a Chief Justice or a Justice of the Superior Court for that matter. And even the lower courts, it is for the judiciary itself to deal with it. Right? Now, I have said that based on history and in trying to deal with the mischief that existed, where Kwame Nkrumah could remove a Chief Justice, these processes were put in place. Unfortunately, I'm saying that unfortunately because most probably the framers of the Constitution did not envision a situation where the Council of State itself could become so politicized in terms of the persons who end up constituting that body. And so they thought that, at that level, there would be some openness of mind, right, where people would assess matters on the basis of its merit alone and not colored by any political biases. As we speak now, and I stand to be corrected, the color of the Council of State as it stands is so green, but we cannot run away from it. And that's why I think that
you say it's so green. Mr. Aban, what exactly are you saying?
So green in terms of political colors.
To put it plainly?
To put it plainly, they are so inclined or aligned with the end that we cannot run away from it. That's why I said that look at the backgrounds and the political leanings of the persons who succeeded in getting elected and those who were appointed by the president on the basis of the powers given him in the Constitution. So that's why I said that it is so green. And so we are dealing with a situation where a president, at a time being a candidate for the presidency, has clearly stated that it would require a new Chief Justice to bring dignity to the judiciary. And that's why I'm saying that it appears to me that these installations and layers layers of hurdles to be crossed before a Chief Justice will be removed were placed there. Unfortunately, the people who are supposed to populate these layers to bring some kind of justice and equity into the process is being bastardized somehow by the way we have got certain kind of persons to constitute the Council of State. So it was well intended, but by the elections that we went through and all that, we have succeeded in making it look so partisan. And that's the fear and expression. And that's what I'm saying, that since it is like that, if indeed the president wants to roll out the hint that he himself gave at the time he was a candidate. So it is easy to get rented, and I'm still using my words, it is easy to get rented petitions, okay, and pliable members of that committee to say that remove him or remove her. And that's it.
Is that what you are? Is that what, from where you sit? Is that what you see happening? You say that rented petitioners have been charged to actually put these petitions forward as part of a grand scheme already indicated by the president when he was not yet president. Is that what you're saying? Plainly,
I'm not overly partisan, but in this matter, this is how I think and how I see it. My friend, English Husseini, knows the way I conduct my politics. We are very good friends, and usually when I'm doing such discussions with him, I feel so good, I feel at home, because he is not overly partisan. I know him very well. But in this case, from a hindsight and all the discussions that have gone on, and of course, I'm sorry to say this in Fante, we say that Usumaya was Mohu. So all the things that they have outlined to do, it's now being played out. So from here, no, it should not come as a surprise to anybody when we will get petitions to remove Jean Mensah. I'm not a prophet of doom, but it will come.
I mean, because you mentioned Jean Mensah, looking at past precedents such as the Charlotte Osei case, what lessons then can we learn to refine our judicial removal processes?
Yes. And that is all the more reason why some of us are saying that, look, this business of the accused person not even knowing what has been said about her or him, it's dangerous. So that you can make a case. I have read somewhere where Charlotte is asking that, look, let me also see the petition against me. And that when you are setting a precedent, be careful. If it was bad yesterday, it should be bad today. And so we must take steps to correct it.
Thank you, Mr. Aban, for that. I beg your pardon. Let me also rope in Mr. Fuseni. And time check, it is some 23 minutes past the hour of 9. You're still live here on 3 FM Sunrise, on 3 FM 92.7. We're talking about the petitions that have been forwarded to the President for the removal of the Chief Justice, Her Ladyship Gertrude Tokonu. And we've got on the lines, telephone lines, Mr. Alexander Aban, former NP, private legal practitioner. We've also got Mr. Inusa Fuseni, also former MP, also private legal practitioner. Mr. Fuseni, weigh in on what you've heard so far, and then I'll ask my final question to you as well.
Well, the sentiments expressed by my friend, good friend, in fact, my good friend Aban, does not in any way mature to give it a color of rightness in the eyes of the law. Why do I say so? You cannot just remove a Chief Justice based on the composition of the Council of State. And let me hasten to add, in this Fourth Republic, every Chief Justice was sat on the bench. There have been petitions for his or her removal in this Fourth Republic. But why has it not succeeded? The composition of the Council of State does not determine whether a petition of the toward the removal of a Chief Justice will be successful or not. This is because the Chief Justice can only be removed on 3 conditions. 3 conditions. The removal of a Chief Justice is not at large. It must be on grounds of stated misbehavior, stated misconduct. It must be on the basis of incompetence. It must be on the basis of infirmity of mind or body that have rendered the Chief Justice incapable of performing his or her functions as Chief Justice. These are the 3 grounds. So any petition that goes to the Council of State must reveal 1 or 2 or all of these conditions before a Chief Justice can be. That is why there's a prima facie.
Right.
That's the benchmark. And let me, Mr. Aban arguing in reverse that when Nana Akufo-Addo said that the petition of Oko-Azar did not reveal any reasonable cause, was not meritorious. Was it that the Council of State, he was not interested in removing Justice Tokonu? Is that what I get Mr. Aban to be arguing, Honorable Aban to be arguing? It is not. It is simply a requirement. Even though at that point I disagreed with the procedure adopted by Nana Akufo-Addo. I thought he did not follow the procedure, and against NHTC, against Boyfiu, the procedure is that the President, in consultation with the Council of State, must determine whether a prima facie case has been raised. In the last month or a day before the President left office, he indicated that the petition submitted by Oko-Azar was unmeritorious. He did not say that in consultation with the Council of State, he had come to that conclusion. So that was my beef. But I say that, yes, Aban, no matter how you see the composition of the Council of State, it can only act on the basis of the grounds provided in the Constitution for the removal of a justice of the Superior Court of Judication.
Mr. Fuseni, thank you so much for your thoughts. I've run out of time for this conversation, but Mr. Aban, if you're still with us, maybe you'd like to summarize your thoughts, also conclude for me in about 30 seconds, and then I can say goodbye to both gentlemen.
Thank you very much. Thank you very much.
Sure.
You see, as far as the law is concerned, the composition of the Council of State does not have any political color. I agree with him. And that's why I said that the framers of the Constitution may not have envisioned that we would get this kind of court. But we cannot talk about the law and leave practical realities out of it. Now he gave the three areas. Infirmity of body and mind may even be an issue that will be scrutinized on basis of science. That yes, medical examination shows that the Chief Justice is either has gone senile or, let me say, is incompetent mentis. So, infirmity of mind. Infirmity of body, it is easy to see that this person is ailing, very sick. And that has rendered the person incapable of doing that. Now, what about stated misbehavior? That is the area where, if we want to have political manipulations, we would have it.
Right.
You understand? And so we should not make it seem as though there are no rooms for people to have value judgment of some kind of subjective analysis made. And so stated misbehavior, if indeed that would be the issue, because for me, anybody who has got up to the point of Chief Justice, unless probably the person was called, he was appointed Chief Justice just from the back. But anybody who has gone through the mill as a High Court judge,
right,
Court of Appeal judge, Supreme Court judge, and gets to the point of Chief Justice, look, I would say that competence is given. Because if the person is not competent, there's no way he would have even risen to that point. So competence is even given. So issue of incompetence may be too difficult a hurdle to cross.
Right. So you say it's the misbehavior that would leave room for that conversation. Mr. Fuseni.
Incompetence, let me draw Justice Mr. Aban's attention to.
Yes, and just 30 seconds or less for me, please.
Incompetence of the Chief Justice. Now, if you are looking for incompetence, it is not only incompetence in the exercise of her judicial functions, but also incompetence in the performance of her administrative or ministerial functions.
I agree with you on that. I agree with you on that.
Well,
but I can assure you that there are a lot of, if I say, administrative setup such that the incompetence, properly so called, of a Chief Justice in the administrative management of the place may not necessarily become so prominent. Anyway, in this episode, when we are done there, can you give me a shout? Let's talk.
Well, gentlemen, it's been an exciting discussion this morning. We're very grateful that you could both join us. And these are the conversations, certainly, that advance the cause of Ghana. So we're grateful that you could take some time to express your views in this manner. Let me say a very big thank you again to Mr. Alexander Kojo Kom Aban, former MP, also private legal practitioner, as well as Mr. Inusa Fuseni, also former MP, also private legal practitioner. Gentlemen, do have a wonderful weekend. Thank you so much for your time.
Enjoy the weekend too.
Thank you. Very fruitful discussions there, but of course, the conversation rages on.